Welcome to this training titled California Statewide Uniform Guideline for Determining Child Support and Senate Bill SB 343. This is a review of the California Statewide Uniform Guideline before and after September 1st, 2024, and other changes from SB 343. This presentation will review child support guidelines prior to September 1st, 2024, why the guideline is changing and other changes resulting from SB 343, how the guideline formula works, emphasizing the K factor, guideline formula changes, K factor modification, the low income adjustment pre and post September 1st, 2024, deviation, multiple cases, and uninsured healthcare and childcare expenses. Throughout this training, you'll be hearing from Kathleen Ayers, Chief Attorney from Tulare County Local Child Support Agency, and Celeste Coker, DCSS Office of Legal Services, Deputy Director and Chief Counsel. Starting with Part 1, reviewing child support guidelines, the guideline formula, and the changes made by SB 343.
Let's begin by reviewing the child support guidelines as they are before September 1st, 2024, and the reasons for the changes enacted in SB 343. In 1984, the legislature, by way of the Agnos Child Support Standards Act, declared that the state of California had no single standard to promote equitable and adequate child support awards. As such, the first algebraic child support formula was born and applied the following year. At that time, the formula was intended to provide for the establishment of a minimum level of support that was at least as much as the AFDC a dependent would receive, or a portion thereof, if the parent's income was insufficient to cover the minimum amount. By 1993, this area of law evolved, and while concepts of minimum standards of care remained within the law, they were no longer at the core of the formula. Rather, income share remained the focus of the general algebraic formula we are most familiar with today, and that is firmly established in Family Code Section 4055. The formula as of 1993 and as set forth today in Family Code Section 4055A is as follows. The child support amount is represented by CS and is calculated by multiplying the allocated income of both parents for child support, represented by K, with the difference between the high earner's net monthly disposable income, represented by HN, and the product of the percentage of time the high earner has custody of the child, represented by H%, and the total net monthly disposable income of both parents. With an overview of the formula in mind, let's take a step-by-step look at how this works. This slide provides a summary with more detail of exactly what each variable represents within the formula we are used to today. In this next series of slides, we take a look at these variables one at a time. The CS variable of the formula represents the amount of child support for one child. The TN variable is the total net monthly disposable income of both parties. It is important to note that a large part of what the guideline calculator software does before even applying this formula is determine each parent's total net income available for child support after taxes and other statutorily permissible deductions as defined in Family Code Section 4059. The H% variable is the approximate percentage of time that the high earner has or will have primary physical responsibility for the children compared to the other parent. In cases in which parents have different timeshare arrangements for different children, H% equals the average of the approximate percentages of time the high earner parent spends with each child. The HN variable is simply the high earner's net monthly disposable income. And finally, we arrive at arguably the most impactful variable of the formula, the K variable, sometimes also referred to as the K factor. The K variable represents the amount of both parents' income allocated for child support, which equals 1 plus H% if H% is less than or equal to 50%, or 2 minus H% if H% is greater than 50%, multiplied by a fraction dictated by the table to the right of the screen. This table shows the K-factor fractions as they exist prior to September 1st, 2024. In the next slide, we will demonstrate exactly how the K-factor works with the K-factor fractions table. As an example, prior to September 1st, 2024, if the total net income available for child support of the parents was within the range of $801 to $6,666, and the high earners visitation or timeshare H% was less than 50%, the K factor fraction would be 1 plus H% multiplied by 0.25, because 0.25 corresponds with the parent's total net income band. Keep this table in mind, as it is the part of the guideline formula that was changed the most in the new guideline effective September 1st, 2024, but more on that later. Next, we will bring the formula together again by applying it to a specific set of facts. In this hypothetical, parent A's net disposable income is $2,000, while parent B's is $1,000. Parent A has 20% timeshare with the one child who is the subject of this calculation. Remember, we took a shortcut here. In the guideline calculator, in order to get to parent A and B's net disposable income, you first put gross income figures into the guideline calculator, apply the proper settings, and then the calculator will determine the net incomes to be used in the formula, just as we are about to do here. Our facts plug into the formula so far as follows. HN is $2,000, which comes from parent A, who is the higher earner. H% is 20%, which comes from the 20% timeshare parent A, the higher earner, has with this child. And TN is $3,000, which is the combined total net income of both parents. Placing all the figures for the variables in their proper place in the formula, this is how it looks so far. But what about that important K factor and the corresponding table? To determine the K factor, remember we start by looking at the first part involving the H%. Since parent A's timeshare is less than 50%, the first part of the K factor is 1 plus H% multiplied by an amount based on the table. Because the total net income from both parents at $3,000 falls between $801 and $6,666, the multiplier is 0.25. So our complete K-factor expression in this case is 1 plus 0.20 multiplied by 0.25, or 1.20 times 0.25 as shown on the screen, for an overall K-factor of 0.30 or 30%. We can now multiply the K-factor, 0.30, by the total of the remaining terms, which is 1,400, to arrive at CS, or child support for the one child, which equals $420. Fortunately, thanks to certified software, you don't have to do this manual calculation to arrive at the same result. As seen here, child support based on our hypothetical, where parent one's total monthly net income is $2,000 and parent two's is $1,000 with a 20% timeshare for parent one, the resulting child support is $420. You'll also notice that a range of support based on the low income adjustment is calculated in this case, and we will cover how that works later. So how would all of this be any different in the new guidelines effective September 1st, 2024? Again, the main changes are in the K-factor table, which we will review as we review the many amendments to the law resulting from the passage of Senate Bill 343.
Let's take a general look at the amendments made to the Child Support Guidelines statutes under SB 343, effective September 1st, 2024. Child support guidelines are not limited to the statewide uniform guideline formula stated in Family Code Section 4055, although that's the first code section that comes to mind when we talk about the child support guidelines. Child support guideline statutes actually extend to Family Code Section 4050 through 4076, including Family Code Section 4057, setting forth the rebuttable presumption regarding guideline formula results and the reasons for deviation from the guideline. Family Code Section 4058, defining the annual gross income of the parents. Family Code Section 4061, regarding additional support for children and its computation. Family Code Section 4062, regarding mandatory and discretionary types of additional child support, as well as Family Code Section 4063, regarding uninsured healthcare costs and payment procedures. The objective of Senate Bill 343 is to bring California into compliance with the remaining requirements of the Flexibility, Efficiency, and Modernization in Child Support Programs (FEM) Final Rule, such as the requirement that each state must have child support guidelines that take into consideration the basic subsistence needs of low-income child support obligors. SB 343 was chaptered by the Secretary of State on September 22, 2023, in the Statutes of 2023, Chapter 213. The operative date of the amended Child Support Guidelines statutes is September 1st, 2024, and the operative date of the amended Establishment and Initial Pleading statutes, such as Family Code Section 17,400 and 17,430, is January 1st, 2026. The foundation and the reasons for the SB 343 amendments to California's Child Support Guidelines statutes can be found in the FEM Final Rule requirements in Title 45, Code of Federal Regulations, Section 302.56, and the 2021 Quadrennial Review Report published by the Judicial Council of California on May 16, 2022. To ensure compliance with the federal regulations as amended by the FEM Final Rule, the 2021 Quadrennial Review Report made the following three recommendations to the legislature. The first recommendation was to modify the bottom income bands of the K-factor table so the total net disposable income of low-income parents would not put them in a band that assigns the highest percentage of income to support. The second recommendation was to update the Low-Income Adjustment (LIA) threshold and to continue to allow for cost of living increases to the threshold. Finally, the third recommendation was to address the adverse impact of the multiplier for multiple children by capping support or providing a deviation factor for support exceeding a certain threshold. Here are the SB 343 amendments to Child Support Guidelines statutes at a glance. SB 343 amends Family Code Section 4055, paragraph B3 by updating all income bands and the K-factor applicable to each income band. Family Code Section 4055, paragraph B7 is amended by increasing the LIA threshold to gross income earned from full-time minimum wage. Finally, SB 343 amends Family Code Section 4055, paragraph C regarding support calculators to codify the current practice of showing the LIA range in every calculation where the net income of the obligor is under the LIA threshold. SB 343 amendments to Family Code Section 4057 add a specific deviation reason that caps guideline support at 50% of the obligor's net disposable income in low-income adjustment cases, and address the court's discretion in handling multiple cases. Amendments to Family Code Section 4058 add severance pay, veterans benefits that are not based on need, and military allowances for housing and food to the definition of annual gross income. SB 343 makes additional amendments to Family Code Section 4061, which changed the default apportionment of expenses to in proportion to the parent's net incomes instead of a 50-50 division, unless a party requests or the court finds on its own motion that expenses should be divided in a different manner. Amendments to Family Code Section 4062 require the court to order only actually incurred child care costs related to employment or to reasonably necessary education or training for employment skills, unless they are specifically included in the guideline calculation. Amendments to Family Code Section 4063 create a presumption that costs actually incurred for child care that is related to employment or to reasonably necessary education or training for employment skills are reasonable. Family Code Section 4063 amendments also make the payment procedures that are currently applicable only to uninsured healthcare costs applicable to child care costs as well, effective September 1st, 2024. Let's continue to Part 2 with a detailed review of each specific SB 343 amendment and the resulting guideline calculator and procedure changes.
As promised earlier, it's time to review the changes to the guideline formula resulting from the passage of SB 343, starting with the K-factor table. This slide demonstrates the K-factor variable and table as it exists before and after September 1st, 2024. The initial part of the K-factor remains the same in both versions. The 1 plus H% or 2 minus H% portion has not been changed, but the K-factor bands, which determine the multiplier, have changed. You will notice right away that instead of 4 income bands for the multiplier, there are now 5. Additionally, you will notice that after September 1st, 2024, the income range for the first income band is larger than it was previously, going up to $2,900 and starts with a lower percentage at 16.5%. Also, after September 1st, 2024, it takes more family income to get to the 25% multiplier. Prior to September 1st, 2024, a family with a combined total net income of just $801 was already at the 25% multiplier. A family doesn't get to the 25% multiplier after September 1st, 2024 until their combined total net reaches $5,001 to $10,000. And that family with 801 would now be in the multiplier band that starts with 16.5% instead of 25%. This graph is just another way to illustrate how the K-factor works before September 1st, 2024 per Family Code Section 4055b3. In this graph, you will notice that the K-factor reaches its highest level of 25% fairly quickly at just $800 total net disposable income per month, and then remains there across monthly income amounts and doesn't start to drop off significantly until it reaches the $7,000 to $10,000 range. Remember, this chart illustrates the K-factor table that was established in 1993, and it essentially reflects the idea that the parents with total net monthly incomes between $0 and $800 are low income, and everything after that is middle income and subjected to the 25% K-factor, the highest K-factor. Parents with total net income over approximately $7,000 start seeing a gradual decrease in their K-factor because that income is considered high. This graph reflects the K-factor table as of September 1st, 2024. For context, every 4 years, pursuant to Family Code Section 4054, the Judicial Council is required to review the child support guideline and to make recommendations to the legislature for appropriate revisions. Based on the most recent quadrennial review and the passage of SB 343, this K-factor table was created based on more current economic data. By expanding the lowest income band and having a second band of income up to $5,000, you see a much more gradual climb to the 25% K-factor. While parents earning between $6,667 and $10,000 per month were considered high income under the former table, receiving a K-factor lower than 25%, they are now considered middle income and subject to the 25% K-factor. The high income percentage decline doesn't happen until a family's combined total net monthly income reaches over $10,000. In modifying and expanding the bottom income bands in this K-factor table, the total net disposable income of low-income parents doesn't put them in a band that assigns them the highest percentage of income to support. This K-factor is better aligned with current economic conditions and the recommendations of the 2021 Quadrennial Review Report. This graph shows the pre-September 1st, 2024 K-factor table in gray and the K-factor table effective September 1st, 2024 in blue. Again, take a moment to notice the difference in incline to the 25% K-factor happening much earlier on the gray line, and the income ranges included in the 25% K-factor being more aligned with the current economy in the blue line, and the greater income required in the blue line to be considered high income and receive the gradual decrease in the K-factor. Let's go back to our hypothetical scenario and see how that family's outcome is different under the September 1st, 2024 guideline. After September 1st, 2024, the formula and the variables are still the same as they were before. Parent A is still the high earner. As such, their income is represented at HN. Their visitation is represented at H% with 20%, and the respective parents' total combined net income, TN, is still $3,000. So what's changed? If you guessed the K-factor, you were right. Based on the September 1st, 2024 K-factor table, the 1 plus H%, or in this case, the 1.20 portion of the K-factor determination remains the same. However, the income band and the remainder of the K-factor change. The total net of the parents now falls in the expanded low-income band, and as such, their K-factor now starts at 13.1% and results in an overall K-factor of approximately 25%. Whereas previously, if you recall, the parents' K-factor started at 25% and resulted in an overall K-factor of 30%. Multiplying the different K-factor to the formula that is otherwise the same, and the total child support is now $339.66, rounded up to $340. And again, thanks to certified software, this calculation does not need to be completed manually. As seen here, child support based on our hypothetical run in the state guideline calculator is $340. You'll see again it provides a range of support based on the low income adjustment, which we will cover next after a quick side-by-side of the hypotheticals applied in both versions of the guideline and their respective results. Focusing on the bottom lines in each equation, you will find that the amount of parent A's income to be considered for support was the same in both equations, $1,400. and that it was the different K factors of 30% and approximately 25% that caused the different overall resulting child support amounts. In this section, we will take a look at how the low income adjustment works and how it changes after September 1st, 2024. The law related to low income adjustment is found at Family Code Section 4055B7 and directs that after guideline is calculated, in all cases in which the net disposable income per month of the paying parent is less than a particular amount, there is a rebuttable presumption that the paying parent is entitled to a low income adjustment. Previously, the presumption could be rebutted by evidence showing that the application of the low-income adjustment would be unjust and inappropriate. The statute now reads that the presumption may be rebutted by evidence showing that the application of the lowest amount of child support in the range would be unjust and inappropriate. Prior to September 1st, 2024, the low-income adjustment was affected in all cases in which the net disposable monthly income of the paying parent was less than $1,500, adjusted annually since 2013 for cost of living increases up to $2,137 in 2024. The amount was previously directly tied to the annual California Consumer Price Index for all urban consumers published by the California Department of Industrial Relations. Effective September 1st, 2024, the low-income adjustment will be directly tied to full-time minimum wage, as established by Section 1182.12 of the Labor Code at 40 hours per week, 52 weeks per year. Per the Labor Code, the Director of Finance calculates an adjusted minimum wage by August 1st of each year, and any change to the minimum wage becomes effective on January 1st. As such, the low-income adjustment threshold will get adjusted at the same time each year. Here you can see the history of the low-income adjustment and note that it generally increased at an average of 4% over the last 6 years, with the lowest increase being 1.7 and the highest being 7.4%. However, when looking at the increase from the start of 2024 to what it will be based on minimum wage effective September 1st, 2024, you can clearly see that the SB 343 change was significant, increasing the threshold by 29.8%. As prescribed by the remainder of the Low Income Adjustment Statute, the formula for the low income adjustment is the low income adjustment threshold less the paying parent's net monthly income multiplied by the child support amount, the sum of which is then divided by the low income adjustment threshold. The result is then subtracted from the child support to achieve a range of support. Applying the pre-September 1st, 2024 low income adjustment threshold to our hypothetical scenario, also using the pre-September 1st, 2024 guideline, we take the low income adjustment threshold of $2,137 less the obligor's net monthly income of $2,000 multiplied by the child support amount of $420, the sum of which is then divided by the threshold of $2,137. The result is $26.93, which is then subtracted from the child support amount of $420 to achieve the range of support of $393 to $420. Applying the low income adjustment threshold for September 1st, 2024 forward in our hypothetical scenario, also using the September 1st, 2024 guideline, we can clearly see that the formula itself for how the low income adjustment is calculated hasn't changed, and are reminded that it is the low income adjustment threshold that has changed. As of September 1st, 2024, the threshold is based on minimum wage of $2,773. Therefore, we take that amount less the obligor's net monthly income of $2,000 multiplied by the child support amount of $340, the sum of which is then divided by the threshold of $2,773. The result is $94.78, which is then subtracted from the child support of $340 to achieve the range of support of $245 to $340. This slide compares the pre-September 1st, 2024 and September 1st, 2024 forward overall guideline results. The changes to the guideline, primarily the K-factor, resulted in support pre-September 1st, 2024 being $420 and effective September 1st, 2024 being $340. Pre-September 1st, 2024, applying the low income adjustment with the threshold of 2137 based on the Consumer Price Index, we achieved a range of support of $393 to $420. September 1st, 2024, applying the low income adjustment threshold of $2,773 based on minimum wage, we achieved a range of support of $245 to $340.
Let's now discuss the impact on support amounts and system changes that are resulting from the K-factor and LIA changes in SB 343. Let's take a look at the impact on child support amounts. This table shows the percentage of change in the resulting support amount at different monthly net disposable income levels for the parent order to pay support. The line highlighted in yellow with $2,337 of net income reflects the net income earned from full-time minimum wage, which our presumed income orders are based on. For example, the current presumed income order for one child with $0 income for the parent order to pay support and zero timeshare for the parent order to pay support is $584. We see an almost 35% reduction in that order amount down to $380 after applying the new K-factor and the new low-income adjustment. On the other hand, a parent order to pay support earning approximately $11,000 a month under the same circumstances would see a 22% increase in their support obligation. This is because $11,000 a month is no longer considered an extraordinarily high income that justifies a lower K-factor percentage in the K-factor table as amended by SB 343. The July 21, 2024 release implements a new functionality in the DCSS guideline calculator that provides a radio button to allow the user to switch between the new SB 343 guidelines and the pre-SB 343 guidelines. The default selection is set to the old guidelines from July 21, 2024 through August 31, 2024. The new guidelines become the default selection on September 1st, 2024. At the bottom of the DCSS guideline calculator page, under the Other Settings section, the users will be able to select Yes or No next to the new field Calculate based on new child support guidelines effective September 1st, 2024. For the new field titled Calculate based on new child support guidelines, starting July 21st, 2024 and until September 1st, 2024, No will be the default selection when tax year 2024 is selected. Starting September 1st, 2024, Yes will be the default selection for tax year 2024. Tax years 2023 and earlier will not provide an option to select new guidelines. The printed results report from the guideline calculator will display which guidelines have been applied right under the tax year, regardless of whether the user has made a selection. For example, If the pre-SB 343 guidelines were applied as default for any calculation run between July 21st, 2024 and September 1st, 2024, the printed results will show that the pre-SB 343 guidelines were applied. This function is critical for the courts and other reviewers to know which guidelines the calculation is based on. The following Judicial Council forms are getting updated with new language related to the low-income adjustment pursuant to the invitation to comment SB 2401 published by the Judicial Council of California. FL 342, Child Support Information and Order Attachment, FL 665, Findings and Recommendation of Commissioner, FL 687, Order After Hearing, FL 688, Short Form Order After Hearing, as well as FL 693, Guideline Findings Attachment.
In this section, we will discuss when and how deviations from the standard guidelines may apply. Family Code Section 4057, in Section A, expresses the foundational rule that the amount of child support established by the guideline formula is presumed to be the correct amount of child support to be ordered. However, Section B expresses that this presumption is a rebuttable presumption, which may be rebutted by admissible evidence showing that application of the formula would be unjust or inappropriate in the particular case, consistent with the principles set forth in Section 4053, because one or more of the factors found in 4057 is found to be applicable by a preponderance of the evidence, and the court states in writing or on the record the information required in subdivision A of Section 4056. That is a lot of code sections to connect for deviation, so let's take this in its respective parts. First, in deviating, the court must do so consistent with the principles set forth in Section 4053, which are: a parent's first and principal obligation is to support the parent's minor children according to the parent's circumstances and station in life. Both parents are mutually responsible for the support of their children. The guideline takes into account each parent's actual income and level of responsibility for the children. Each parent should pay for the support of the children according to the parent's ability. The guideline seeks to place the interests of children as the state's top priority. Section 4053 continues, children should share in the standard of living of both parents. Child support may therefore appropriately improve the standard of living of the custodial household to improve the lives of the children. Child support orders in cases in which both parents have high levels of responsibility for the children should reflect the increased costs of raising the children in two homes and should minimize significant disparities in the children's living standards in the two homes. The financial needs of the children should be met through private financial resources as much as possible. And finally, Section 4053 reminds that it is presumed that a parent having primary physical responsibility for the children contributes a significant portion of available resources for the support of the children. The guideline seeks to encourage fair and efficient settlements of conflicts between parents and seeks to minimize the need for litigation. The guideline is intended to be presumptively correct in all cases, and only under special circumstances should child support orders fall below the child support mandated by the guideline formula. Child support orders shall ensure that children actually receive fair, timely, and sufficient support reflecting the state's high standard of living and high costs of raising children compared to other states. So it is with these principles in mind that the court can then look at the factors in 4057B to determine if there is a preponderance of the evidence that one or more apply. The factors found in 4057 are: the parties have stipulated to a different amount of child support under subdivision A of section 4065. The sale of the family residence is deferred, and the rental value of the family residence where the children reside exceeds the mortgage payments, homeowners insurance, and property taxes. The amount of any adjustment pursuant to this paragraph shall not be greater than the excess amount. The parent being ordered to pay child support has an extraordinarily high income, and the amount determined under the formula would exceed the needs of the children. A party is not contributing to the needs of the children at a level commensurate with that party's custodial time. 4057 continues with a new basis for deviation starting September 1st, 2024, resulting from the passage of SB 343. This new basis for deviation is at subsection 5 and explains that if a support obligor qualifies for the low income adjustment and the amount of child support established by the formula exceeds 50% of the support obligor's net disposable income after application of the low income adjustment, the court can deviate in any amount so long as it is not greater than the amount exceeding 50% of the support obligor's net disposable income. 4057 then continues with another deviation factor, that the application of the formula would be unjust or inappropriate due to special circumstances in that particular case. These special circumstances include, but are not limited to, those described in subsections A through D. So with the principles from Family Code section 4053 in mind, and having proven at least one factor of 4057 by a preponderance of the evidence, the last step for deviation is found in 4056A, which reads, "To comply with federal law, the court shall state in writing or on the record the following information whenever the court is ordering an amount for support that differs from the statewide uniform guideline formula amount under this article. The amount of support that would have been ordered under the guideline formula, the reasons the amount of support ordered differs from the guideline formula amount, the reasons the amount of support ordered is consistent with the best interests of the children."
Now let's take a closer look at the new deviation factor in Family Code 4057B5, added by SB 343. The criteria that need to be met for this deviation reason to be applicable are as follows. 1. The support obligor's net disposable income qualifies the support obligor for the low-income adjustment. In other words, in year 2024, the support obligor earns less than $2,773 in net disposable income per month. 2. After the application of the LIA, the guideline support amount, the lowest end of the LIA range, exceeds 50% of the support obligor's net disposable income before support. If these criteria are met, the court may deviate in an amount not greater than the amount of guideline support exceeding 50% of the support obligor's net disposable income. For example, if the lowest end of the LIA range in the guideline support calculation is $1,250 and 50% of the support obligor's net disposable income is $1,000, the court may deviate in an amount not greater than $250, resulting in a support order of $1,000 to $1,249 for basic child support. Child support add-ons are not considered as part of the comparison between guideline support and 50% of net disposable income. After the release scheduled for August 18, 2024, DCSS Guideline Calculator will display an informational message when the criteria under Family Code Section 4057B5 are met. The informational message will read, "The lowest amount in the low-income adjustment range exceeds 50% of the support obligor's net disposable income, X dollars. See Family Code 4057B5. In the message, X will be equal to 50% of the support obligor's net disposable income. This informational message will display on the user interface as well as the printed results. Since only the court has the discretion to deviate and apply the 50% cap on the support obligation, the message will serve only as a notice and will not prevent the user from moving forward with their guideline calculation. This slide shows screenshots of the notice that will display on the DCSS guideline calculator. The notice in blue displays on the user interface, and the black and white screenshot shows the printed results. The following Judicial Council forms are being revised pursuant to JCC Invitation to Comment SP 2401 to add language regarding the new deviation factor under Family Code Section 4057B5. FL 342A, Non-Guideline Child Support Findings Attachment, FL 687, Order After Hearing, FL 688, Short Form Order After Hearing, FL 693, Guideline Findings Attachment.
In this section, we will review the new law created by the passage of SB 343 to be effective September 1st, 2024, related to calculating child support for parents with multiple child support orders, as well as demonstrate how these calculations can be done. The new law is found at Family Code Section 4057C and reads as follows. If the court is made aware that a parent is subject to multiple court orders to pay child support arising from a different case or cases, the court may take steps to determine how to allocate the parent's income and support obligation appropriately across the cases. A court that continues a hearing based on a party's representation that it will file an appropriate request to modify support in a related case may issue a temporary support order. You may have noted that the new statute does not require the court to address the multiple cases, nor does it expressly state how the court must allocate the parent's income across cases. However, it does provide a path and legal authority for a process that is well established in many local child support agencies. The process has been known to some as dueling or toggling the cases. Within the guideline calculator, there is a field in the monthly deduction information section titled Child Support Paid, Other Relationships. This field is part of the calculation pursuant to Family Code Section 4059, the section that addresses what is considered in calculating net income. At Section E, it explains that when calculating the net income for a parent, the following should be considered. Quote, any child or spousal support actually being paid by the parent pursuant to a court order to or for the benefit of a person who is not a subject of the order to be established by the court. In the absence of a court order, child support actually being paid not to exceed the amount established by the guideline for natural or adopted children of the parent not residing in that parent's home who are not the subject of the order to be established by the court and of whom the parent has a duty to support. Unless the parent proves payment of the support, a deduction shall not be allowed under this subdivision. End quote. If you place another child support obligation in this field, it will inevitably change the child support amount you are calculating. And if you then place this new child support obligation in another case, it will change that obligation. And this will continue in multiple cases until finally all child support calculations stop changing and the income is equalized across the calculations. Let's use a hypothetical to see how this dueling or toggling works. Imagine parent 1 has a stipulated off-guideline order with parent B for $800 in county Y, and an order after hearing for child support with parent 2 for $600 in county X. Parent 1 was recently laid off and is now receiving unemployment income. Parent 1 applied for modification of child support in both counties and has court hearings set on different days. The hearing with parent 2 in County X is set first. Remember, we are in court in County X where the order is currently $600, and we have all the other correct facts in the calculation for the parents. And then, in the child support paid other relationships field, we input the $800 that parent 1 is currently ordered to pay in County Y. This causes support in County X to change from $600 to a low income adjusted range of $38 to $79. You could then input the lowest end of the range, $38, in the calculation planned to be used for the hearing in County Y in the child support paid other relationships field for that calculation. When doing so, it causes the County Y obligation to be a low income adjusted range of $220 to $262. If you then place the new proposed County Y obligation back into your County X calculation at $220, the calculation will again change. The new County X obligation now shows a range starting at $164. And again, if you put the $164 County X amount into your proposed calculation for County Y, the County Y obligation will change. The County Y obligation now starts with a range of $181. And now you can watch as this continues to change back and forth between the two calculations until support finally equalizes. Finally, you will arrive at two calculations that stop changing because the number in the paid and other relationships line is accurate, and as such, the respective support calculation amount is accurate. Here you will see that ultimately each calculation arrived at a range of $177 to $228, while also accurately showing the other relationship obligation in its accurate amount at the lowest end of the range at $177. A few other things to note regarding working multiple cases at the same time. While in this example, support came out the same in both cases, in most cases that would not be the result. Generally, persons receiving support in different cases have different timeshare arrangements and different incomes, and as such, the calculation results in the various cases will be different. Nonetheless, this process will still work. Just trust the process of going back and forth, also known as dueling or toggling your calculations, and you will see support equalize across the cases. Another note is that this does clearly require cooperation of all parties involved, and where local child support agencies are involved, this may be easier as the agencies are used to cooperating in this way. This process may also require cooperation between different court judges or commissioners, where it is identified that the cases would be easier to handle if they were heard on the same day. For example, with parents appearing in each court by Zoom or being present in one court and appearing by Zoom to the other. While this process may have existed in certain jurisdictions for some time, the new legislation certainly promotes it as a standardized way to properly allocate a paying parent's income across their child support cases. This next series of slides will show how the passage of SB 343 impacted the code sections related to uninsured healthcare expenses and child care expenses. Code sections impacted were Family Code Section 4061, which starting September 1st, 2024, directs an apportionment of expenses based on parents' net incomes unless a party requests or a court decides otherwise. Family Code Section 4062, which mandates only ordering childcare costs actually incurred unless those costs are included in guideline calculations. And Family Code Section 4063, which aligns the time for providing costs to the other parent for childcare expenses with the law as it exists related to uninsured healthcare costs. Additionally, Family Code Section 4063 expresses that costs for childcare related to employment or education are reasonable. Let's take a close look at each of these sections, starting with Family Code Section 4061. Previously, the code section expressed that uninsured healthcare expenses and childcare expenses should be divided by 1/2 unless a parent requested a different apportionment. Now it reads that these expenses shall be divided in proportion to the parent's net incomes as adjusted pursuant to subdivisions C and D of this section, unless a party requests or the court finds on its own motion that expenses should be divided in a different manner. Note, subdivisions C and D remain unchanged in terms of instruction on how to arrive at the proper proportion of each parent's income. As to Family Code Section 4062, you see that the language remains that the court shall order the following as additional child support: childcare costs. And then the new language expresses if those expenses are actually incurred, along with the new language referring to Family Code Section 4063 as to how those costs should be managed unless those costs are specifically included in the guideline calculation itself. In terms of managing uninsured health expenses and childcare costs, Family Code Section 4063 in subsection A, starting September 1st, 2024, makes clear that both uninsured health expenses and childcare costs are covered under this section. Otherwise, this section works as it always has in directing parents as to what is required for a reimbursement order, except that the cap on the time frame for providing costs to the other parent has been extended from 30 days to 90 days. Other changes to Family Code Section 4063 starting September 1st, 2024 are found in subsection D and G. D simply provides that the existing rebuttable presumption that costs actually paid for uninsured health care are reasonable also applies to child care that is for employment or reasonably necessary for education or training for employment skills. Subsection G changes effective September 1st, 2024 by applying the previous standards for determining the unreimbursed healthcare expenses to childcare costs and separates what should be considered by the court when determining reimbursement for healthcare expenses in G1 and childcare costs in G2. Subsection G1 considerations for the court when ordering a parent to pay unreimbursed health expenses remains otherwise unchanged. A new section effective September 1st, 2024 for unreimbursed childcare costs is at G2 and adds considerations similar to those in G1, but directed at childcare, of course, where it reads in Part A, the nature and extent of job-related childcare needs, including but not limited to work schedule needs and the duration of education or training for employment skills. Part B, the necessity and reasonableness of the cost, though reasonableness is not part of the health insurance expense considerations, and parts C and D, considering the special needs of the child and the reasonable inability of the parent to pay the full amount of reimbursement within a 30-day period, resulting in the need for a court-ordered payment schedule.
Now let's take a look at DCSS guideline calculator changes related to the child support add-ons. When the new guidelines are applied, SB 343 amendments to Family Code Section 4061 require the guideline calculator to default to the prorate per Family Code 4061B option under the Allocation for Child Support Add-ons section. With this change, the DCSS guideline calculator will reflect the computation that is considered the default apportionment of child support add-ons. However, as noted in the previous slides, any party to the action can request a 50-50 division or any other apportionment of child support add-ons. From July 21, 2024 through August 31, 2024, the default selection will remain as 50-50 since the old guidelines will continue to apply by default until September 1, 2024. When the user switches between the old guidelines and the new guidelines, the allocation for child support add-ons will always correlate with the new selection. Selecting the old guidelines will move the child support add-on radio button to 50-50. Selecting the new guidelines will move the child support add-on radio button to prorate per Family Code 4061B. Users must remember to move the allocation for child support add-on selection back to 50-50 if they select the new guidelines but would like to keep the 50-50 allocation of child support add-ons. This is particularly important when a child care expense amount is being included in the guideline. It is also important to note that unless a child support add-on amount has been entered in the guideline calculation, the printed results do not show how the child support add-ons are to be divided. The requested division is indicated on the Judicial Council forms.
That was a great presentation from our subject matter experts. To summarize this training, in Part 1, we provided an explanation of child support guidelines applicable before September 1st, 2024. We presented the reasons for the guideline changes and other revisions in SB 343 and a detailed breakdown of how the guideline formula functions, with a particular emphasis on the K-factor. In Part 2, we gave an overview of the modifications made to the guideline formula, especially the adjustment of the K-factor. We explained the low-income adjustment before and after September 1st, 2024, as well as the consideration of deviations from the guidelines. We addressed handling of multiple cases and uninsured healthcare and childcare expenses, and we also went through the child support add-ons. This training was developed by DCSS Statewide Training Section in partnership with Tulare County Local Child Support Agency and the DCSS Office of Legal Services. If you have any questions, please email DCSS Office of Legal Services at the email shown on this screen. This concludes this training. Thank you for your time and have a great day.